719 would allow for ex parte protective orders to remove your Second Amendment rights, not because of criminal conviction or mental adjudication, but based on third-party allegations and evidentiary standards far below those normally required for the removal of constitutional rights. As currently drafted, the respondent will first learn of a protective order has been issued against them when the law enforcement official shows up at their door and requires them to surrender their firearms. Under this bill, the respondent loses a fundamental right without any notice of a judicial hearing, without the opportunity to be present, without even being offered the opportunity to provide a written statement for the court to consider before removing their gun rights. We have offered some amendments to address some of these concerns. The -A11 amendment would require the respondent to be notified in advance of a hearing and be given an opportunity to be heard. We requested 3 judicial days for the notice, but we are not married to that number. We just chose a number. The -A12 amendment addresses another concern that we have with the bill, in that law enforcement officials in this bill can take action on their own without the assistance or without the notification or any even contact with a family or household member. In the Senate testimony, it was testified that the law enforcement officials could assist family or household members in this protective orders. This bill goes much beyond that and allows law enforcement officials to do that without any notice of a family member or any contact with a family member. The -A12 would fix that piece of this bill. And finally, the -A13 amendment restricts this bill only to household members. As you just heard from Mr. Sterrett, this bill, as drafted, allows any family member, whether they've had contact with that person for years or decades, to ask for a protective order, or any person living in the same household. That's in the current bill. The -A13 amendments would restrict that to only persons living in the same household. We feel that those amendments would much improve the bill if you're going to move forward. While we would not support the bill, at least those would somewhat protect some constitutional liberties of people who are potentially facing these protective orders. While we believe this is a well-intentioned piece of legislation, it is a minefield of potential abuse and does nothing to protect those who may be suicidal or the family members of people who are truly dangerous. If an individual is truly dangerous, existing law already provides a variety of mechanisms to deal with the individual, all of which can lead to firearm prohibitions and inappropriate cases. The issuance of a protective order does nothing to deal with the underlying cause of dangerousness, nor does it subject the person to any physical restraint, ongoing reporting, monitoring requirements, or treatment for any underlying mental conditions. There is nothing in this bill to offer aid to those who are self-destructive or safety for people living with those who are prone to violence. While the described intent of the bill is to prevent suicides, this bill would do nothing to actually prevent future tragedies. This law targets deadly weapons and ignores the fact that individuals use other methods to inflict harm. This bill merely takes away a tool, but then it continues to leave the individual at risk of harming themselves or others. Furthermore, no law can give police or even family members increased insight into human behavior or motivation. Thank you for your opportunity to testify. I urge you oppose Senate Bill 719.
Thank you both.